my answer would be Wright versus University Hospital of Cleveland, which is at 55 Ohio Ave. 3rd, 227.
Mr. Winter, what was my question that you're responding to?
Oh yeah, sure. Judge, you had asked me what's the length of time for the statute of or the tolling statute to run? Does it ever run on these folks? And I indicated that I thought that issue had been decided. I couldn't remember what it was, Judge. So I went back and looked at it, and the operative language is, it says where a defendant leaves the state after a cause of action accrues against him, he, quote, departs from the state within the meaning of the tolling statute, and the time of his absence is not computed as to any part of a period within which the action must be brought. And what page is that at?
Well, that's just quoting the statute. I think I was asking if there's any outer limit on that, or if it can just run in perpetuity.
Well, in Wright, the doctor retired to California, Judge, and he was sued. He made, unlike Dr. Durrani, Dr. Wright made it back for trial, but the court held that the tolling statute applied until he came back to Ohio.
Well, but Mr. Wright, or I'm sorry, Mr. Winter. So, but in this case, if I'm looking at the timeline, hadn't Dr. Durrani, he had fled after the statute of repose had already lapsed?
No, sir. No, sir. The statute of the 4 years would have run on January 31st, 2015, because the surgery was on January 31st, 2011.
You're just talking about Ms. Robinson Woods, right?
That's right.
Right.
We'll talk to the other folks in a minute. But
we don't need I mean, based on our disposition on the savings statute, that the abscondment isn't really, I mean, the abscondment is basically moot in virtue of how we've handled the savings statute issue.
we just have alternative arguments, Judge Bergeron. I just get your money's worth.
Can I ask a question, even though maybe it's moot? When did Miss Robinson Woods discover that she was injured?
We contended it would be in July of 13, and that's pled, I think, at paragraph or page 4 of the complaint. No, 5. I'm sorry, 4. Yeah, she became aware that BMP2 was implanted in her in July-ish of 2013. So even if you run the 1 year from that point, the first case was filed on February 27 of 14, within 1 year, and in any event, that timeline was, or excuse me, that the statute of limitations was told when he left in December of 13. Did I answer the question?
Thank you.
Okay. Yes, ma'am. Just 2 other things. I have preserved for further review the issue of the court's inherent power to attenuate fraud that the legislature can't take away. And I've also asked you to consider again whether fraud claims, both pre and post surgery, are not medical claims. And I'd just like to say, here's another case of where we have the scheme, not for a medical benefit, but for a financial benefit, of these defendants doing unnecessary surgeries, getting paid by insurance companies, and just making false representations and concealments. And I'll leave that as it is. If we could, that's all I have for Ms. Woods.
And Mr. Winter, I guess with respect to the other 3 cases, are there any issues in there that we have not already decided, or that our prior precedent doesn't squarely answer that you wish to raise?
You have, well, we've already, the answer is the past precedent addresses the issues. I'm preserving them for appeal, but I just like one point, and maybe it's just me, I didn't do a very good job in the briefs or prior arguments, but with regard to negligent credentialing, under the Browning, Schelling, Schmitz line of cases is not a medical claim. Negligent credentialing arises out of a hospital's credentialing or retention of an incompetent doctor. It does not involve the medical diagnosis, care, or treatment of a person. 2 points, hospitals are not permitted to practice medicine under Ohio law, which is revised code 4731.41, and paragraph 14 of the Schelling case states that. So we could, under the Estate of Stevick case, in order to have a negligent credentialing claim, there's a 2-step process. One consists of whether there's been medical diagnosis, care, treatment of a person, and that can never occur here. So we can never get to those interesting issues of whether a caretaker or physician, all those things that this court has addressed. And I'm just asking you to please take a look at Estate of Stevick, 121 Ohio State 3rd 488. And with that, I agree, you have addressed the issues. I just ask you to please take a look at that. And I'm done. Thank you.
All right. Thank you, Mr. Winter. Mr. Herzig?
Myself. Good morning, Your Honors. Aaron Herzig for Appellees Dr. Durrani and Cast in the Robinson Wood matter ending in number 515. May it please the court, I think, as you know, you've already addressed many of the issues in this brief. We're waiting to find out what the Ohio Supreme Court's view of the Wilson Sand issue is. And one thing I would note, I think, is that decision and the language that they use might affect how this court looks at not just the interaction between the reversal saving statute and the statute of repose, but these other statutes, because all of these cases come up in the context where plaintiffs have made their own strategic choices in litigation, had cases filed in one county, decided to dismiss and refile en masse in Hamilton County in an effort to create a mass trial or group of mass trials. And now, as a consequence of that, are trying to cut away at the true statute of repose that the Ohio Supreme Court has declared. I think it's important that it uses the word true statute of repose. The Ohio Supreme Court is signaling that after years of battles between the General Assembly and the court over the extent of medical claim tort reform, that the statute of repose imposed by the General Assembly at 2305.113C is a true statute of repose. It ends cases after 4 years. It bars cases under C2 that have not been brought within 4 years. And all of these cases now come up in an effort to carve out, either by implication or I think by importing from the statute of limitations into the statute of repose, exceptions that the General Assembly did not intend and did not write. And I think you can see that at 2305.113C, where they say very specifically, except with regard to 2305.16.
Let me ask you about that, Mr. Herzig, because the statute of limitations in A also has that same language, except as provided in this section, which is 0.113. But we know, for instance, if you think about the tolling statute, the abscondment statute that Mr. Winter referred to earlier, that clearly applies at a minimum to the statute of limitations. And so this except language to me doesn't seem to be all encompassing, and that the only provisions must be within that statute, because we know the General Assembly has created other exceptions that aren't referenced in that statute. So why can't they do that?
Your Honor, I think it's because these are different types of statutes meant to be read differently. A statute of repose is a, quote, true statute of repose intended to terminate claims. It has not been, and what's interesting is—
I understand that. I understand that they're different. But my question is, the language you pointed to, the except as, is the same language in the statute of limitations. So why should we give those two kind of identical language different interpretations?
I wasn't intending to address the question. I think I understand what Your Honor is saying about the words being the same. I think the context matters. I think that the General Assembly has been clear, and Ohio statutory construction has been clear, that different types of statutes can be interpreted in different ways, and indeed must be. And one way you can tell, I think there are a couple differences. While the words there might be the same, number one, the statute of repose has a very specific scheme, very detailed, frankly. If you look at section D that lists the specific exceptions, there's a lot of math required about when you discovered this or what happened there. And I think that shows that the General Assembly, in fact, intended this to only have very specific exceptions. But more broadly, I think that's true of every statute of repose. I think when a court is confronted with a statute of repose, it should come at it assuming the validity and permanence of it in a way that you don't necessarily have to in a statute of limitations. I think they are fundamentally different. I think the Ohio Supreme Court has said that several times. I think the US Supreme Court in CTS Corp and other cases has said that. And I think a way you can tell is statutes of limitations, the exceptions that appellants argue for have not been found with regard to a statute of repose, including the absent defendant statute. It has not been, this absent defendant statute has not been applied to a statute of repose. There was one old 10th district case that did so when the statutes were written very differently and the exceptions were flipped, where there was the implication that anything not included was not excluded was included. We now have the different.
Well, but there was a Judge DeLotte decision that did that. And I guess when you say courts haven't done that, I also don't see the flip side. I don't see courts taking the opposite position. I just think it hasn't been addressed.
So fair, Your Honor. Number one, of course, Judge DeLotte and the federal courts have to take their cues under Erie from what this court does. And so at most, I would suggest that what the Southern District has done in these cases is advisory. Second, you're right, it may not have come up yet in this specific context, but perhaps that's because everyone understands that the statute of repose is in fact meant to terminate these cases. This does not come up typically because it's actually a fairly generous statute. You've got the statute of limitations that allows for discovery, and then you've got 4 years to find out and bring your case if you can do it within the statute of limitations. These parties had, at least Ms. Robinson Wood had met that with her first complaint. This comes up because there are consequences to a 41A dismissal. I think another problem with the context of some of these cases is that it's easy to forget that 41A and the reversal saving statute have never been a free pass. If the law changes before you file your new case under the reversal saving statute, you live with the new law. If rules of evidence change, you live with the new rules of evidence. So while appellants might have thought that there would be no consequence to a 41A dismissal for their strategic purpose of bringing these mass actions. That's never been true. And I think it's all the more important to remember that in connection with a statute of repose, where the Ohio Supreme Court has not found an exception to limit that statute of repose in the cases that have come before it. So I think statutes of repose are intended to be read more strictly, and perhaps that the same words used in both statutes don't have exactly the same import because of the strictness of the statute of repose. I think there's no doubt that the General Assembly intended to end these cases if they were not brought within 4 years. And based on Antune, the new filing of the 41-8 complaint is a newly commenced case. It may not be the policy choice that we would make, but that is the policy choice that the General Assembly has made, and justices across the political spectrum have recognized that in these various cases, including Ruther and, of course, Antune. I think I've addressed most of what my concerns are there. I did get a chance to listen, and I appreciate now that the court is putting these things on video. I got to listen to the Elliott argument a few weeks ago, the first time the court really addressed the absent defendant statute. And I think part of what was missing from that was a broader understanding of how we came to a set of cases where we have to wrestle with all of these potential exceptions, including the idea that a medical claim somehow stops being a medical claim if the person who committed the alleged tort stops being a doctor at some future point. These are real stretches here. And I think the challenge is, the fact of that and the challenge of that demonstrates that we really should be imposing the statute of repose as written. It's also the case that while the policy implications of the absent defendant statute have not been particularly relevant to the limitations idea, I think if this court is going to extend the absent defendant statute to the statute of repose, it needs to consider those policy implications more, to consider them again, frankly.
Mr. Herzig, the General Assembly put 113 specifically in 15. So, I mean, they've made a policy determination themselves, right?
Well, so two responses to that. One is 113 comes later in time, and number two is stricter. I do think you look at the narrower statute first. And so my argument, my response to that would be that while it does fall within those sections, it in fact is not intended by the General Assembly because of the nature of a statute of repose. It's also the case that, of course, the language of 2305.15 is the language of limitations. It speaks of accrual and limitations periods. It does not speak of repose periods or when a claim will ever accrue or vest.
The problem with that is the General Assembly doesn't speak about that either. If you look at 113, it doesn't use the word limitations. It doesn't say statute of limitations. It doesn't say statute of repose. Like, the legislature hasn't carved that language out in that manner in 113. That's how we talk about it in opinions, but it's not what the legislature says.
Yeah. So, Your Honor, two responses. One is, it's not just how we talk about it, it's how the Ohio Supreme Court has used the words true statute of repose. I think they have real import. But number two, where they do use the word limitation is in the absent defendant statute. And so to me, that says they were talking about a different thing than a statute of repose. And yes, they don't use those words in 113, but when they do in 15, they're distinguishing between the two.
Mr. Herzig, also in 15, they do talk about the period of limitation, but they also talk about for the commencement of the action. And when I look back at 113, the word commence is not only used in the statute of limitations section, but it's also used in Part D of the statute of repose, where it basically gives you a new timeline to commence your action. So I guess I'm just kind of looking at the words commencement when you're, because the whole point of this tolling statute is, when are you supposed to file your action? And does the time to commence your lawsuit stop at some point? And so I guess that's where I'm kind of getting tripped up on the language of this statute, because it talks about beginning a lawsuit, and part of the statute of repose tells us when you can begin a lawsuit.
Your Honor, I think what I would argue is that the word commencement there is simply describing the words immediately before it, the limitation period, the period of limitation for the commencement of the action. So I think the way I would read that, and the way I do read that, Your Honor, is that we're talking about the period of limitation again here, not the period of repose or the time that a claim is forever extinguished. Right? A repose statute doesn't just tell you when a claim is brought, it tells you when a claim is extinguished forever, even perhaps before you've ever discovered it. There is no doubt that repose statutes can have what plaintiffs will feel is a harsh result, but that is the nature of them, and that is what the General Assembly intended them to be. It intended to end suits or prevent them from ever being brought, from them ever being even accrued as injuries. And so I think when you read those two things together, you have to read the statute of repose as a very strict rule. And I think there's a reason why the Ohio Supreme Court has continued to uphold it over time against efforts to read exceptions into it. Unless Your Honors have other questions, thank you for your time.
Thank you, counsel.
Yes, thank you. May it please the court, Jennifer Mitchell, again, on behalf of the Christ Hospital in the Beckelheimer, Benton, and Ayers cases. As the court pointed out, and as Mr. Winter conceded, this case is like many that have previously been ruled upon by the court, and most recently in the Jonas decision reached by the court and rendered on July 22nd, 2020, which addresses, I believe, identical issues to those presented before this court in each of these three cases. In fact, two of the three cases were decided at the same time as the Jonas and Carr cases, and the other came shortly thereafter. So I don't know that I need to elaborate much into any of the arguments that have been previously addressed by the court. Mr. Winter did raise the issue of the Browning case and its progeny. I believe this court addressed that, those decisions previously as well in Young and Christinger, and more recently in Freeman and Jonas, in rejecting the argument that is being espoused by Mr. Winter that the Browning case somehow should continue to be followed, or that it applies to the new definition of medical claims, which came about 20 years after the Browning decision. And especially in light of General Assembly commentary at the time of prior revisions to the language on what the definition of medical claim is, which very clearly stated that the language that was being utilized so as to supplant Browning, and its definition of negligent credentialing was supposed to be included in the medical claim definition. That happened again over 20 years ago. And since that time, the definition of medical claims has been vastly broadened to include negligent credentialing. So I would just reiterate that the Browning decision and those other cases cited in conjunction with it by Mr. Winter's clients have already been addressed and rejected by this court, and the court should do likewise here. Thank you.
Thank you, counsel. Mr. Winter, you still have your rebuttal time, sir.
Just a couple points, or well, more than a couple. Mr. Herzing again disparages my client's use of Civil Rule 41A to dismiss without prejudice and refile. There's a case decided by Justice Stewart when she was at the 10th district, which says that the plaintiff's right to 41A dismiss is unfettered, and there needs to be no rhyme or reason to it. And as long as the case is timely refiled, as the court knows, under Wilson Sand and its progeny, the case is still alive under Freisinger. We agree that there's a second point that we have a true statute of repose here, but yet even under that same standard, the Ruther Court reserved the very issue of Wilson Sand, and that's what Mr. Herzing and I are litigating up at the Ohio Supreme Court over. One thing that Mr. Herzing and I agree on, I thought I heard him say that under 2305 113C2, he says it bars cases not brought in 4 years. Judge Mock, that's what you said in your concurring opinion in McNeil dealing with Ralph David Scott's claim. But this case was brought within 4 years. And following your analysis there, we don't have to go through all the things that the Wilson Sand and other courts have done. That C2 preserves the case for so long as the plaintiff complies with 2309, 2305, excuse me, .19. Another point that was made was we have a difference in the statute of limitations versus statute of repose. I thought it was brought out, and if it did, I'll be quiet, but our General Assembly used the word limitation when enacting 2305 113. It didn't use repose, it used limitations. So
And I'm sorry, Mr. Winter, what are you referring to?
There's some discussion during Mr. Herzig's analysis of that we have different standards for under 2305 113 for under A, statute of limitations, and C, statute of repose.
But you said there's specific language in 113 about limitations. Is that right?
Well, the title of the statute is called limitations. Are you all still with me? There's somebody trying to call me.
Yes,
We can hear you. Your video feed has stopped, Mr. Winter.
It's just an adverse counsel in another case. Excuse me. I'm sorry, judges. Counsel. The fact is that Judge DeLaw took a look at this argument and said there was nothing to it. And the second thing is that it would treating the repose that we now call repose in court versus a limitation leads to an absurd result. Let's just say that, for example, only the statute of limitations in subsection A is told, but the limitation in subsection C continues on. Well, at some point, limitation in subsection C is going to overcome the limitation applicable to subsection A and overwhelm the tolling provision. So I'm speaking about 15A there. So it applies. The only thing I would say with regard to Ms. Mitchell's argument is that our discussion about supplanting Browning, all that's in the brief. We've discussed it. I'd just like to add that the Landrum court said that there's a conflict between this court's interpretation of negligent credentialing and two other districts. Judge DeLaw didn't like their result. I happen to like it, but one thing that Judge DeLaw and I can agree on is that there's a conflict. And at some point, we're going to have another motion for a conflict, and I respectfully request that you consider that. And that's all I have for you. Thank you for your time. Any questions for me?
Questions? All right, thank you, counsel. Thank you, everyone, for your arguments this morning. All these matters are now submitted. We will review them and issue timely decisions. Thank you all.
Thank you, judges. Thank you, Ms.
Thank you, Your
Mitchell.
Honors.
Thank you, Your Honor.